Give me basics of what we have discussed in yesterday's class. Is the voice clear? Chalo. Given the basics of it, we started a business entity yesterday with the logic of company law. Students who have joined today's class, we have already started the very basics of company law. I'll revise that and we'll get into the concept. So what happened? We started a business entity and we have concluded with the logic that any kind of business entity will require two things. What are two things required? Finance and skill. Finance has to be there for this initiation of a business. Any business can start only when there is existence of finance, but the business can be profitably run only when we are having access to skill. And we must have skill in one area or all areas of business. Both of them combined together is gonna make the business profitable in nature. If at all assuming you don't have skill in your hand, can you start the business? You cannot even start the business with a lack of skill, or you cannot even run the business profitably if you are not having skill. If you cannot start the business if you don't have, and you cannot run the business profitably if you don't have skill, which becomes important for the business entity. Both of them. So we started the logic that will initially start with a sole proprietorship. What do you mean by sole proprietor? If it is a single owner, this single owner is going to bring in finance and the single owner himself is going to bring in skill. So there will always be a lack of finance and lack of skill to do the business at a large scale, at a huge scale of business. It is not possible for a single person to bring in skill and finance on his own. Then we started converting our sole proprietorship into a partnership firm of a business where partnership had multiple partners in it. We can have minimum of how many partners? Two and a maximum of. Give me the basics on that. Minimum two was not given by the partnership law. It was indirectly given by the contract act based on the word agreement, and the word 50 was given by the Companies Act. Now partnership will have, assuming they have two partners, can I say they have the double amount of finance, double the amount of skill as compared to a sole proprietor? They can do the business at a larger scale and they can do business in a more efficient manner. Which is better, partnership firm or in sole proprietorship? Because it has more amount of finance and more amount of skill. I can do business at a little larger scale as compared to sole proprietorship. But partnership firm comes with its limitations. It has limited liability or unlimited liability. Partnership, unlimited liability. And the partnership is restricted to a maximum of 50%. Now, for example, we started a business activity. We don't want to restrict ourselves to a particular state. We wanted to do business at a national level. To open, say, 50 to 100 branches or such, whether 50 partners will be enough to bring in finance. Then we had to even expand the business. Then we converted into a company form of a business. This company form of a business was introduced in India in the year 1850s. Initially started as a joint stock company. We didn't used to call it as Companies Act. We initially called it as a joint stock company. Later it got evolved and the first Companies Act came into existence in 1913. After that, it got repealed and reenacted as 1956. Later, the 2013, which we are learning today. And there are speculations that this is also going to change in the very near future. 2013 is going to change, but more or less the process has been remaining the same. Companies Act is that kind of an regulatory authority who regulates and administers all the companies in India. Now, get to the basics again. This company is going to focus on the topic of finance and skill. Coming to the finance part, who are the persons who are going to bring in finance for a company? Shareholders. Now, did we focus on the amount of money brought in by each person, or did we focus on the number of persons? So in case of partnership firm, we had a restriction on 50, but when it comes to the company form of business, we did not have the restriction. We increased the number of persons with a limited amount of finance. End of the day, we were able to raise a massive amount of money to do business at a large scale. That is possible only in case of a company, not in case of partnership, nor in case of a sole proprietor. But this amount of money also comes with its disadvantage that this 1 crore people don't have skill. These 1 crore people will not have knowledge. These 1 crore people will lack the process, lack the time to come and spend in the business activities. Hence, what we did is the topic of skill was separated from the investors, and we have brought in who have been brought for the skill purpose, conceptually called as what? Experts, but technically under Companies Act we call them as directors. Each one of them separately is called as a Director, all of them combined together are called as board of directors. Now, listen to this topic carefully. We'll use it in the future also. Say we have a panel of directors. Say we have 4 directors in the company. Each director is an expert. Get the logic clear? Each of the director is an expert. Now, for example, you, a cost accountant, are appointed as a director in the future. One of the director is a cost accountant. What are you expert in? Guys, you're in final level. What are you expert in as a cost accountant? What are you expert as a cost accountant? And more? Okay, you are expert in the cost reduction, cost management. Fine. There is another person who is, say, a marketing expert who knows how to market the product, who knows how to advertise the product in the market. Now, can I say both the experts are completely different from each other? One person doesn't know what is cost, one person doesn't know what the price is to be set up, but one person knows the logic of marketing. Do we be able to, we as a cost accountant, whether we will be able to do the marketing activity? We are not an expert, we are basically not even novice, we are not even having basic knowledge of marketing. But on the other hand, whether there is another, say, another person who's gonna take care of the legal activities, can I say each expert has their own domain of expertise and each person is separate from each other. Now go back another category, another person, say this last category, for say Akash Karma. Akash, the director, he's a second class fail. Can he act as a director? Yes. Because Companies Act doesn't define any qualification criteria. Any person can act as a director. Doesn't matter if at all he has knowledge of the business. Can he be appointed as a director? Doesn't matter his qualification. I don't care of his qualification. I'm only here to appoint experts. I don't want academic qualifications. If at all he is assumed to be having proper amount of knowledge to run the business, but doesn't have academic qualification, can he still be appointed? Yes. Now understand this. He knows how to operate the business. He knows how the manufacturing process goes on. Now, which director is important for my business? Can I remove one of the director and still run the business in optimum manner? So can I say each one of the director brings in different aspect, different perspective, different knowledge to the business, and each director becomes important for me? Now taking the process, I'll even simplify it for you. If say there are 3 directors, and we'll simplify the categories into purchase, marketing, sales. There are 3 directors, 3 different domains. If a director having only purchase knowledge runs the business, business will be profitable or making losses? It's good. If the person having only marketing knowledge runs the business, business will be making losses. If the person having knowledge of purchase, marketing, and sales combined together run the business, company will be. That's the reason Companies Act starts with the wording, we never give powers to a director, we give powers to the board of directors. All of them combined together will take decisions, bringing in all the perspectives of their expert knowledge. It is not a logic that one director runs the business. Who runs the business? Board of directors. That will depicted again under section 179. Start remembering the section numbers, guys. Section number 179 talks about powers of a board. Should I use the word powers of director or powers of a board? Powers of a board, because I want the expert knowledge from one domain or all the domains. All the domains combined together is going to run the business in optimum manner. That's where the powers are starting from. Who has powers? Director or board of directors? But we started the logic that board of directors are not actually having power. Who actually has the power? Shareholders. But do the shareholders have enough time to come and spend in the company? Do the shareholders have enough skill and knowledge to run the business activities? Then they delegated their powers to the board of directors. So actually speaking, the power is in the hands of shareholders, but they delegate their powers to the board of directors or directors. Board of directors, how do they delegate their powers? By drafting the documents, MOA and AOA. These 2 documents are indirectly called as the constitutions of the company. These documents provide powers to the board of directors to work on behalf of the shareholders. So can I indirectly conclude that board of directors are principals or agents? Agents, but they are agents of whom? Agents of the, who is appointing board of directors? Who is appointing board of directors? Company with the help of the shareholder. We'll discuss that again under section 152. We'll come back to this logic. The process of appointing board of directors is not done by the shareholder themselves. It is done by the company, a separate legal entity with the help of the shareholders. So indirectly, the board of directors are agents, but they are agents only of the company, and the company is an agent of the shareholders. Can I conclude that principal, the shareholders are having an agent company, but company is also acting as a principal and having a board of directors as an agent. You guys know the logic of sub agency now. Company, can it control board of directors? Yes. Shareholders, can it control the company? Shareholders, can they control the board of directors? Indirectly, answer is yes. Though they are not directly an agent, they are sub-agent. They can still control the board of directors. So conclude with a one-liner. Can a shareholder control board of director? Yes, not directly by himself, but through the company. Can the company control the board of directors? Yes. Board of directors are always appointed by the company with the help of the. Okay, don't stuck with the word company. You should always continue the sentence because there are exceptions in the future. Board of directors are appointed by company with the help of shareholders. There are some exceptions in the future. We'll segregate them slowly. So come to this logic. Once the board of directors have been established, once the shareholders have been established, we'll start doing the business activities. Now, before we start business activities, before we enter into transactions, let's understand the basics of a company. We'll start with the word finance first. Finance is brought in by whom? Shareholders. Remove that wrong perception in your heads now. Finance is not only brought in by shareholders. Can I go get a bank loan? Can I borrow money? Can I accept deposits? Can I accept debentures? All that is also a finance for me. So finance is basically of two types. We have own fund and debt fund. Debt fund is something which is not going to be accepted by the company to keep it with itself. It's going to be repaid back. But own fund, it's going to stay with the company. It will become the core capital of the company until the company goes into liquidation. That own fund is brought in by the shareholders. Now listen carefully. This finance part is divided into two parts for us now. Own fund and the debt fund. Which is more important? Own fund or debt fund? Own fund or debt fund? Okay, fine. We'll analyze the topic. If at all you have own fund, how much are you bringing in? Check your pockets quick. How much? 10 rupees. How much are you bringing to the business? Cheppanama. Your savings from your articles, how much? Give me a random number. How much? 10 lakhs. Say you have invested 10 lakhs of your own fund. Okay. Now, can I say, give me some sources of finances. How will you bring in? One is your savings. Or what else? Banks, borrowings from bank loans, good. Prashant Gadama. Bank loans, what else? Think, what else? Where can I bring in finance? Selling assets, some property might be sold off and brought in money. Mortgage can be taken, good. I'll put my property as a security in the bank and get some loan out of it. Good. Can we all agree that the sources are limited in nature? You agree, you know how to run a business, you know how to get finances, but you still are thinking on what source I have to go for. That means the sources available for getting finance is always limited in nature. If it is limited in nature, can I say the amount brought in by you as a own fund is also limited in nature? Can you always satisfy the business needs with only own fund? No. We have to always go get a debt fund. Own fund will never be sufficient enough to run the business in a optimum manner as we have imagined. We should always go and get a debt fund. But if imagine this, if you don't have own fund and you go to a bank for loan, you have not invested a single penny from your pocket, but you go to a bank and ask for loan. What's the first thing the bank asks? The first thing the bank asks is, if you don't believe in your own business, how would I believe it? If you have not invested your own money into your business, how would I believe in your business and how would I invest into it? So the bank will give you debt fund only based on the risk you have involved into the business. If say you have invested 1 rupee and go to the bank and ask 1 crore, will the bank provide the loan? You have to invest in the business first to take risk on your own and believe in your own business. Then the bank starts believing you. So debt fund is possible to be raised only when you already have invested own fund. But own fund alone is not sufficient enough. Now, can we come to the agreement that both of them are important? Only own fund is not sufficient. Only debt fund is not even possible. So I can do the business at the desired level only when I have own fund and a debt fund. Focusing on the own fund as of now. This own fund is brought in by whom? Shareholders. Now, get to the basic knowledge of shareholders. What happened here was the company, for starting a huge project, assuming not 10 lakhs, 20 lakhs, we're gonna start a huge business entity, will require a total capital of 1000 crores. How much capital is required? Now, how many of you are ready to invest 1000 crores? 1000 crores. Check your bank balances. How much is there? Less than 1000 rupees. Will you find a single person that is gonna ready to be bring in 1000 crores? No, not even Mukesh Ambani. He'll also think about it. It has to be involved with huge amount of risk to invest this huge amount of money. No single individual is going to be ready to invest huge amount of finances. Hence, what did the company do is the entire capital of the company that is required for business was divided into small parts. That small part was called as share. Share is nothing but a proportionate, a part of something. Capital's part is called as a share. Technical name, where does this technical name fall from? The entire capital of the company was divided into small parts, and that small part is indirectly a part of the capital. That part of the capital is being given a name called as share. So what are we doing here? Rather than selling the capital to the investor, I'm selling a part of my capital and calling it as share. So it will become easier for the company to raise finances by selling capital or by selling shares. I'll be able to easily find the investors. I'll be able to easily find investors if it is shares or capital. And guys, it is not equal in nature, but should be equal in nature. Drawing ratledanta clear ga should be equal in nature. So entire 1000 crores will be now divided into what? Small parts. Each of the part is called as what? Share. Now the company will be selling shares or capital. It should be equal, okay? And it will also happen in this way. Just imagine that this each small part is called as a. Now share, as we have learned under Sale of Goods Act. Go a little back into Sale of Goods Act. Give me the definition of a good. Remember, good means every kind of movable property other than actionable claims and money, currency money, but includes shares and stock. Share is a good. Share is a good or not? Yes. Remember that. We'll come back to this concept. Say for example, Akashram, come here. Now imagine a simple sale contract. I am a seller, Akash is a buyer. I'm selling a small good. A remote is being sold here. Imagine a simple sale contract. What's going to happen? Two parties are there. One is seller, one is buyer. A good has been sold and I'm expecting price from the opposite party. I'm selling a good. Once the good ownership has been transferred, what is expected from the buyer? Price. Money is the how many parties are there? Two parties, seller and buyer. What is being sold here? Goods. And I am expecting what from him? But did he pay the price yet? That means whether it is executed contract or executory contract, where I still have a right to receive money, and I have a right to receive money because he has not paid it today. I can demand the money in the future. Now the same thing is happening under Companies Act also. Company states that we have imaginarily created a good called as share. Who is selling the share? Company. And who is purchasing the share? A person called as a shareholder. And he has agreed to pay the price, not yet paid the price completely. Can the company demand for this price? Now this what happened here, basically a sale contract was entered between the company and the investor, where company happens to be selling the shares and the investor happens to be purchasing the shares for a particular price. But did he pay the price on the day? That means the company has a right to receive whether contract is discharged. Whether contract is discharged. The contract will be discharged when? When one promise is performed or both the promises are performed. What are two promises in this basic contract? Promise from me as a company was Share. Promise from him the investor was to pay price. Did I give him the share? Where is the share? Show me the share. Where is the share? Share is an imaginary thing created by the company. I divided my imaginary capital into small parts and I called it as a share. There's no physical thing called as a share, but to provide evidence that it is a share, I'll give him a piece of paper called as share certificate. But there is no physical thing called as a share. There's no tangible thing called as a share. I'll give him an evidence called as share certificate. Now, for example, previous example, what happened, we have sold a good, the good has a tangible criteria, I've given the good to the third party, the buyer. But this case, because the shares are not having any tangible criteria to it, I'll not give the shares directly to him. I'll give a document called as share certificate that will evidence that he is holding the shares in the company. Got the logic? Now what has the company given to the buyer? Share means indirectly what? Share certificate, and the shareholder has to pay price. Have I given the share certificate? Yes. Has he paid the price? No. When the contract is discharged. When will the contract be discharged? Both the promises, assuming he has to pay a total price. We have agreed to pay a price of 10 and he has paid rupees 8. Whether his promise is performed or part performed. If it is part performed, where the contract is discharged, contract will be discharged only when it is fully performed, assuming he has paid rupees 10. Where the contract is discharged. Yes, the contract is still existing. Contract is not discharged. The promise given by the buyer is performed, but my promise is still left out. What is my promise? What is my promise? Giving him share. That's the wrong intention you have. Share certificate is not my promise. The share certificate only gives an evidence that you are eligible to certain rights in the company. I, as a company, until you hold this paper, am obligated to provide certain rights to you. Say right to attend general meeting, right to receive the notice of general meeting, right to dividend, right to vote, right to inspect the books of accounts. These are the rights which the company should be providing to the shareholder until he holds this paper called as share certificate. That means my right is not going to end on a single day. My right is not going to end on a 1 month basis, 2 months basis. I have to continue to provide the rights until he holds the paper. Share certificate. Now, can I say this part of the promise? Are you going with the concept? I'm being a little quick on this logic. Are you guys comfortable? Pace is fine enough? This performance is completed, but the company's part of performance is still pending. Company has to continue to provide the rights. That means the share contract is gonna continue between the company and shareholder even after payment of entire amount of face value, entire amount of value of the shares. Even after payment, the contract continues because whose promise is still pending? Company's promise, and the company has to provide this promise until the share certificate exists. Share certificate is portraying what? Shares in the company. But shares in the company will be existing until the company is existing. If the company is liquidated, if the company itself is not existing, there's no logic of shares in the company, there's no logic of rights in the company. Then the company has to provide these rights in the company until the company goes into liquidation. Once the company has itself closed, there is no topic of discussing rights in the company, attending general meeting, right to vote. That is possible only when the company is existing. So these rights must be provided by the company until the company goes into liquidation. Now I'll give you a small scenario. Give me the answers here. If say this is the entire timeline of the process and you have paid rupees 8 up until this point. Standing here, give me the answer whether contract is discharged. If not discharged, why? How many promises are pending? One or two? One from the shareholder, he still has to pay 2 rupees, and one from the company still has to provide rights. Good. The shareholder later paid the rest of the 2 rupees also. Standing here, the contract is discharged. Still no. How many promises are pending? Still one. Whose promise is pending? To provide the rights to the shareholder. Now, this last case where the company is going into liquidation. Once the company's liquidation order has been passed, standing here, where the contract is discharged. Yes or no? Yes, because how many promises are performed? Both the promises, contract is discharged. There is no existence of contract. Slightly modify. You have paid rupees 8 and the company goes into liquidation before the entire amount is called, where the contract is discharged. Think and answer. Contract is discharged. Answer is no. Think about it. Slowly analyze the logic. Whether company's promise is discharged. As soon as the company goes into liquidation, my promise to provide rights is discharged. But whether your promise is still existing, you still have to pay how much? Whether your promise is existing. Yes, that means your liability will arise on even after liquidation. You as a shareholder are liable to pay rupees 10 even after the company goes into liquidation. That means your contract will be discharged only after payment of that too, even after liquidation where the contract is going to continue. Get the logic clear? The contract never discharges on liquidation. Contract discharges on the performance of both the contract, both the promises. Whether company's promise is discharged. Yes. Whether shareholders' promise is discharged. Shareholders promise to be discharged, he still has to pay. After the payment of that 2 rupees, contract will be. Now for say he here in this case pays rupees 2. Whether contract will be discharged now. Yes. Now a simple one line question. Is the contract discharged before liquidation? Is the contract, share contract, discharged before liquidation? No. Is it discharged after liquidation? It is not depending upon liquidation at all. Got the logic? Doesn't depend upon liquidation, depends upon the performance of one promise or both the promises. One promise from the company to provide rights, other promise from the shareholder to pay price. Now, you went and purchased a good. Say you simply went into a supermarket or you went into a supermarket and purchased a good worth rupees say 100. You purchased some chocolate worth rupees 100. You'll pay how much? That is worth rupees 100. You'll pay how much? Assuming you took a credit of 2 days. After 2 days, you'll pay how much? You'll pay how much? 100. There's no second doubt in it. You have already paid rupees 80. How much will you pay? Same thing happens in the share contract. You've already paid rupees 8. How much will you pay? That means your liability is 2. Now imagine this from the company's perspective. Assuming I the company, have issued you the shares, you have paid rupees 8 to me. How much was the promise to pay? 10, but you have paid rupees. Now can I say my pockets are filled with rupees 8? With this rupees 8, I'll go enter into transactions with the third party. I'll do my business activities. Are you concerned about business activities here? No. Who does the business? Not the shareholder. Who does the business? Company does the business. But company does the business with the help of whose finances? Shareholder. The shareholder paying that 8 rupees fills the company's pocket and the company uses this 8 rupees to go enter into a transaction. Now this company with this 8 rupees goes and enters into contract with a third party. But contracts, business contracts are uncertain in nature. I might incur profit or loss here. If I have incurred a loss with the transaction amounting to 3, amounting to say 1 rupee. Give me the answer here. I have already received how much from the shareholder. With this 8 rupees, I went and entered into contract with her. And I have incurred a loss of 1. Now as a company, give me the answer. Do I have a liability? Yes. How much liability? 1 from this contract with a third party. But on the same concept, I have an asset. Asset from the shareholder contract. How much asset is there? I can demand this 2 rupees. Demand from whom? That's the reason it is also called as a demand instrument. Company can come and demand its money at any point of time. Company can demand how much? If you have already paid rupees 8, company can demand how much? If my liability is only 1, can I demand only 1? Can I demand 2 rupees? Can I demand 3? Yes or no? That means I can demand a maximum of 2. I can demand either 1 or I can also demand 2. Maximum I can demand is, if I demand 2 rupees, you have to pay rupees 2. Your liability is how much? Liability is how much? You have not paid rupees 2. Your liability is how much? 2 rupees. Your liability is a maximum of 2. Can I demand for 1 also? If I demand for 1, you'll pay only 1 rupee. If I demand for 2 rupees, you'll pay rupees. So your liability indirectly is depending upon the unperformed part, unpaid value of a share. I hope you are comfortable with these words, right? I'll directly jump into the wordings. Your liability is what? Limited to the unpaid value of share. Irrespective of what's happening with the company and third party, you are only concerned with the company with the share contract. If say assuming this contract, we have incurred a loss of 3. Okay, third party, for example, Ankit. The company has to pay Ankit a amount of 3 rupees, but the company can recover from the shareholder Akash only rupees. Company is in a situation to pay its liabilities? Yes or no? Company can get how much? 2. Company has to pay how much? Is it in a situation to pay its liabilities? Whose headache? Not yours, because you were never a party to the contract. Who is a party to this contract? Only the company and third party, Ankit. You, the shareholder, were never part of this contract, hence you are liable or not liable. You are not even liable for this transaction. You are liable only for this transaction entered with the company for purchase of share. So get this clear. You are never responsible for the contracts entered by the company. You are never getting benefits out of the contract entered by the company. You are only having one relation with the company based on the share contract. Only the shares. Other than that, you are responsible and you are obligated with nothing else in the company. Any doubt in this? If the company goes and incurs a loss of 30 rupees, who will pay 30? Not your headache. Whose headache? You will be liable to pay only. Should I use the word 2 or maximum of 2? Company can demand how much? Maximum of 2. The shareholder has a liability of maximum of 2. If the shareholder's liability is limited in nature, limited to how much? Limited to the unpaid value of a share. Any doubt in this categorization? Clear am I ikkada? What has happened? What was the conclusion on this topic? The shareholder is liable to the company's liabilities. Yes or no? Is the shareholder liable for the company's debts? Who is liable for the company's debts? Company itself. What is the shareholder liable for? Only for the share contract, where he is liable for the unpaid value or paid value. So what would be the right sentence? Shareholder is liable, but for what? For the unpaid value of a share. Hence his liability is limited or unlimited. And his liability can arise at what point of time? Can it arise during the continuation of business? Can it arise even after liquidation also? Then his liability can arise at what point of time? Any point of time. But once the company goes into liquidation, the shareholders, in this particular case, the shareholder still has to pay how much? The shareholder is still liable for how much amount? You will not be called as a shareholder after the company goes into liquidation. Once the company has gone into liquidation, if the company is not existing, the shares created by company are also cancelled. If the shares are not existing, you are not holding the, then if you are not holding the shares, you are not called as a, but you will be given a different name called as contributor. You contribute to the payment of liabilities of the company. You have been given a separate name after liquidation called as contributor. Until liquidation, you are simply called as a shareholder. You are holding the shares of company, shareholder. But once the company goes into liquidation, because the shares are not existing, you'll be called as what? Contributor. Contributor means a person who contributes to the assets of the company, which will help the company to repay its liabilities. Got the logic? He's contributing to assets or liabilities? He's contributing to the assets so that these assets will be used to pay the liabilities. He's called as a contributor. When will this word contributor be used? Once the company has gone into liquidation. Before liquidation, I'll simply call him as a shareholder. After liquidation, I'm calling him as a contributor. The same logic will also apply for a guarantee. Quickly listen, guarantee I'm not going to spend much time here. Company, you the investor. You wanted to provide money to the company for doing its business activities. Now, at the initial stage, assuming company got incorporated today, where the company has a background, where the company has market share, does the company have goodwill? Does the company have reputation? If the company doesn't have any background, nobody will believe on the company. And the persons believing on the company will be only the shareholders to begin with or the promoters to begin with. Now what happened? This company goes to a bank for raising loan. Will the bank provide loan? If I was a bank manager, I wouldn't have provided loan. Because the company has not proven itself in the market yet, I don't believe the company, I wouldn't provide the loan. But what happened here? The bank was ready to provide the loan on the guarantee given by a investor. Now, if the company doesn't pay the money in the future, I'll be able to still recover the money from the investor. Basically, a contract of guarantee. A contract of guarantee is entered here where investor is giving guarantee to the bank for the loan taken by the company. Now, can I indirectly say company is an artificial person? Company doesn't have emotions. Company doesn't have any thought processes. Company only wants finances in its pocket to run the business. Doesn't matter whether it is coming from the investor, doesn't matter it is coming from the bank. I want money in my pocket. Can I say investor has helped the company to raise that finance? Not directly coming from the investor's pocket, but it is been brought in with the help of the investor. Whether I can call him as a shareholder. He's not holding any shares. He has not purchased any shares of the company. I cannot use the word shareholder. I'll use the word guarantee holder. He has given a guarantee to the company. He'll be called as what? Guarantee holder. Who is giving guarantee? Investor giving guarantee to the bank, stating that if the company fails to repay the loan in the future, I'll come and pay it. But the word fails to repay here is being linked with the topic of liquidation. We will assume that until the company is existing, the company is a rightful person to repay the loan. Once the company goes into liquidation, because the company is not going to exist in the future, there comes a liability for the guarantee holder. Now, replicate this answer for this logic. During the continuation of business, if you are acting as a guarantee holder, whether your liability will arise? No. Your liability will arise only when the company makes a default, when the company goes into liquidation. So your liability as a guarantee holder will arise only after liquidation, but your liability as a shareholder will arise at what point of time? Any point of time, either during the continuation or even after liquidation. But as a guarantee holder, your liability arises only after. But once the company goes into liquidation, you'll be called as a contributor. Any doubt? So give me the wordings and liabilities in a single chart for both the logics. So this is the date of liquidation for us. During this period, the company uses the word either shareholder or you are called as a guarantee holder. Shareholders liability will arise in this period, yes or no? Yes or no? Yes. Guarantee holders liability, no. His liability arises only after. But after liquidation, I cannot use the word shareholder, guarantee holder. I'll be using the word contributors, and contributors liability will arise at what point of time? After liquidation, yes or no? Yes. Any doubt in that? Clear on these logics? So one word answers quick again. Whether shareholder is liable for the company's debts. Whether shareholder is liable for the share contract. Yes, he is liable for the unpaid value of a share, which is limited or unlimited? Limited in nature. I'm not gonna stress much on this topic. You already know this, so quickly answer. Company is an artificial person or natural person? Quickly listen, guys. There's a small linkage between this and partnership law. Quickly listen. In case of a company form of a business, we have a concept called as corporate will. What is corporate will? What is corporate will? The word veil actually translates to parda, basically a curtain. The word veil translates into the concept called as parda. Parda in Hindi basically called as curtain. Now what happened here is the shareholders of the company are the natural persons, but company happens to be a artificial person. Does the company have brain? No. Company doesn't have thought process. Company doesn't know what is right, what is wrong. Everything will be a directions given by the shareholders or even the board of directors. So who controls the company indirectly or otherwise the on a day-to-day basis who controls the company? Board of directors. On an ultimate basis who controls the company? Shareholders. But they are not going to control the company directly. They are going to hide behind something called as corporate veil. And this company which is being directed, which is being used as a puppet, goes and enters into contract with a third party. Now think and answer properly. Step into the shoes of the third party. Third party, while it is entering into contract with the company, it is only able to see the, but not the persons hiding behind the corporate veil. It is not able to see the shareholder. It is not able to see the, if something goes wrong in this contract, this third party will come and demand money from, because he never knew the existence of shareholders and board of directors. That's where the corporate veil comes into existence. It separates the company and the shareholders and board of directors. That's where the concept comes in. Separate legal entity. We are separate from our members because of the logic corporate veil. Apply the same concept in case of partnership. I'm not going to draw it, just imagine this. Who is going to go enter into contract in a partnership? One of the partner goes and enters into transaction with a third party, but there is no existence of corporate veil. Third party can see whom? One partner or all the partners? Because there is nothing for me to hide behind, the third party will be able to see not only the partner with whom he is entering into contract, but also all the other partners. Hence the logic. Acts done by one partner, who is liable? All the partners. But company use the same wordings. Acts done by the company, who is liable? Company itself. Because other parties who are directing the company are hiding behind the corporate company kadama hiding behind the corporate veil. If they're hiding behind the corporate veil, can the third party see them? If third party is not able to see them, third party is in the perception that he's entering into contract only with. If it is a partnership firm, there is no corporate veil. Third party is able to see one partner or all the partners. He'll come and demand money and recover money from all the partners. But in case of company form of business, the third party will be able to recover money only from company. Hence, give me the wordings. Acts done by the company, who is liable? Company goes and makes a loss, liability. Company goes and makes a profit out of the transaction. Who will enjoy the profit? Oh, shareholders. If it is loss, let the company suffer. If it is profit, we'll enjoy it. If the same logic applies on the other end also, if the company makes a loss, who will incur the loss? Who will suffer the loss? Company. If the company gets a profit, who will benefit out of the profit? Company itself. Shareholders have no right on the profits of a company. Shareholders have right only on the concept called as dividend. We'll get to the chapter. I'll explain that clearly there. The company is a rightful owner of the profits or liabilities of the company. No other person. The shareholders are separate from the entire logic. So there comes a very first feature of company called as separate legal entity. For this separate legal entity to exist, the company must be incorporated. We'll go into the incorporation process also. But once a company is incorporated, why do we call it as a legal entity? Can you see the company? Where is the company? Our institute is also a company. Where is the company? VRR. Where is the company? Show me the company. Where is the company existing? There are 15 lakh companies in India. Where are companies? Show me the company. Company is in? It doesn't have physical form. But can you see the company? Yes, sir. Show me. Can you see the company? Can you touch and feel the company? Company is a tangible thing or intangible thing? But if you look it from the eyes of law, you can see the company. That's the reason it is called as a legal entity. It is not an entity which is able to be touched and felt by us natural persons, but from the eyes of law, it is actually existing. Whether company is imaginary or real, that's again the wrong step you take. Company is real in nature, but it cannot be touched, felt, and seen. Real or imaginary? Real. It is not fictitious in nature. It is actually existing. But can you see it? Air, oxygen. Is it existing? Where? Now, same logic on company. Company, is it existing? Yes. Where? In the eyes of law. Not in the eyes of a natural person. In the eyes of law, company is still existing. Company is treated as a separate individual. It is given all the rights as a human being has. Every single right you as a human being have is also possessed by the company. Can you file a suit? Company can also file a suit. Now, company is an artificial person or natural person? Can you fall ill? Can you, Amma? Okay, you're natural person or natural, artificial person? Natural person. Can you fall ill? Can you die? Can you get married? Sigurd Can you get married? Can a company fall ill? Can a company die? Can a company die? Yes. Can we kill the company? Yes. But that is technically called as winding up liquidation. Yes, the company can die, but who will kill the company? Not shareholders. ROC will kill the company. Company comes into existence based on law. Company ends its life based on law by a process called as liquidation. But technically speaking, can the company die? No. But can we kill the company? By following? By taking a knife or by following law? Law. Can we kill parent number? Last bunch. What's your name? Spelling? Pri Priyatham. Okay. Okay, fine. Priyatham is a natural person or artificial person? Artificial. Natural or artificial person? Can we kill him? Simply by a knife? Okay, once the class is done, if you bring a knife, can we kill him? Don't try it, but can he die? Yes, but an artificial person, can it die? It is called as artificial judicial person, created by the law. That's your first feature of a company. Now, and we have also seen this. Okay, we'll go to the applicability part later. Once it is a separate legal entity, once it has its own separate name, etc. I'll go through this. We already know these topics. Can the company go and purchase properties? So it will have its own separate properties. This was not possible in case of partnership firm because partnership firm was never treated as a separate legal entity by the law. If the contract has to be entered, who enters the contract? Partner. If the property has to be purchased, who purchases the property? Partner. But in case of company, who purchases the property? Company. So company can purchase its own property and the rights on the property will be on the company. Now assume, just take a small example, assuming you're all the shareholders. Each one of you have invested X amount of money into the company and the company in total had an amount of 10 crores, went and purchased a building. This building belongs to whom? Can the shareholders come and exercise rights on the building? No. Again, the same logic, you have only entered into a single contract with the company, the share contract. Whatever company does with this finances is none of your headache. Company will take care of business activities. If property is purchased, property belongs to the, no rights on the properties are are privileged to the shareholders. Shareholders have no right on the property. Whose rights? Only the company. Separate property is there. Then, assuming Priyatham, Priyatham, he's gonna, after the class is done at 1 o'clock, he's gonna sing a song for us. Half an hour. Should be fine to prepare? No, he's gonna sing a song. How many songs? Two songs, sir. Fine. Which language, Amma? Which language? At what o'clock? Or at what time? 1 p.m. How many songs? Two. Okay. And Gopi sir classes, huh? Now, continue. We have agreed to pay him price. He has agreed to sing songs and we have agreed to pay price. How much? 2 rupees. Very fine. 2 rupees. Okay. What happens if he breaches the contract? Who will suffer? We'll suffer. No one. Will suffer if he doesn't sing, or will suffer if he sings? Sorry. For example, if he doesn't perform the contract, whether we will be the party losing out of it. So what the law states, whenever there is a party breaching the contract, other party can demand him to perform specific performance. If he doesn't perform the contract, he has to pay damages. Who has suffered loss here? We or Preetham? We have suffered loss because of his breach of contract, whether we have a right to claim damages. Now, if at all, what happens before 1 p.m. if he dies? Just an example, if he dies before 1 p.m. Don't laugh, he's dying there. If he dies before 1 p.m., what will happen? Contract will be cancelled, discharged. Why? Whether his legal representative cannot perform it. Why? Good. The contract is depending upon skill. If the performance is depending upon skill, who should perform the contract? The promiser himself. Can any other person perform it? No. For example, after listening to his song, we died. I mean, not because of his song, but we died. Now, whether we have to pay 2 rupees, whether it is our promise, if we die, whether contract is still existing. Because our promise is not depending upon skill, it can be performed by any person. The same logic is used by partnership and the Companies Act. Listen carefully now. Say there are 3 partners, A, B, and C. Okay. Each of the partner is going to bring in what to the business? As a partnership firm, start with a partnership firm, 3 partners. These partners are going to bring in finance or skill? Both. Partners are going to bring in both finance and skill. Say 10 crores of finance, 10, and say 12 crores of finance. Should it be equal? Finance need not be equal here. And they have brought in skill also. We started with the logic that partnership is a relation between persons, and that relation is based on an agreement. Partnership deed is mandatory or partnership agreement is mandatory? Partnership deed is nothing but an agreement in written format. Agreement may be either express or implied. Agreement is mandatory for starting a partnership firm. Give me the logics here. Can I say it is indirectly a contract? Contract entered between how many people? Agreeing to bring in what? Finance and skill and run the business activities. Got the logic clear? If one of the partner dies, the contract is depending upon skill, and if one of the partner dies, can it be replicated or replaced by his legal representative? Hence, the agreement will be discharged. If the agreement is discharged, there is no existence of partnership. The partnership was formed based on the agreement, and if the agreement is not existing, partnership is not existing. That's the reason on the death of a partner, partnership will go into dissolution, because the agreement is depending upon skill. Same logic applied for a company. In case of company, if there are 3 partners, sorry, 3 shareholders, 3 members, and they have brought in a X amount of finance, are the members bringing in skill? Are the members bringing in skill? No, members are bringing in only finance. We were not expecting skill from them. We brought skill from whom? Board of directors. Now, if one of the member dies, let him die. Who cares? Let him die. Who cares? We are not depending upon the skill logic here. If he dies, his legal representative will come and perform the contract. Hence, the agreement entered between the shareholders members will not come to an end on the death of a death of a member. There comes the logic perpetual succession. If, for example, Gautam dies, Gautam, one of the shareholder, if he dies, what will happen? Nothing will happen. Company will still run its business activities. Doesn't care whether Gautam is alive or dead, whether it's gonna still happen. Now if Gautam dies, who will gonna perform his contract? Legal representative. Who will come? Chinna Gautam. So who has died? Gautam. And who will perform the contract now? He'll gonna still pay those finances to the company. Where the company is still satisfied. Company doesn't care where the finances are received from. Company only wants finances in their pocket. Company doesn't have emotions here. What happens if he dies? See? 2.0. What happens if he also dies? Whether the succession topic is going to continue. That's the reason it is called as perpetual succession. Perpetual is continuation. Continuous succession topic will apply if a shareholder dies. Because of the fact that it is not depending upon skill, it's going to continue to apply. That's the reason we give it the word perpetual succession. Perpetual is continuous. Succession is transferring the assets or liabilities to a legal hire. So the perpetual succession topic will continue until the company actually closes up, until the company goes into liquidation. That's one of the features of a company called as what? Perpetual succession. You have done with 3 features. I know you already have knowledge of all the 3 features, but you don't know the background how it was implemented. So I'm going a little detail on them. First point was separate legal entity because of the logic corporate will. Company acts done by the company. Who is liable? Company itself is liable. Company makes a loss. Loss belongs to the company. Company makes a profit. Profit belongs to the company. Second category is separate property. Whenever company has been, once the company has been incorporated, company is treated as a separate legal entity. Can the company purchase its own properties? The property is purchased from the finances given by the shareholder, but the shareholder has no rights on the property. Properties rights are all in the hands of the company itself. And the last category, last thing we have discussed is perpetual succession. Company will continue even on the death of a member. Death of a member will not affect the company's existence. We have this famous saying, members may come, members may go, company goes on forever. What is the sentence? Members may come, members may go. Doesn't matter. Company goes on forever. Company is a perpetual entity until the company is liquidated by law. Company has no life until it is been liquidated. Liquidated by whom again? Law. It is incorporated by law. It is liquidated by also. Any doubt in these 3 features? Clear on the concepts? We have one more feature called as transferability. I'll come to this once I've explained the private and public company concept. We have one more feature called as common seal. Now this common seal is not mandatory, as you know. It got amended in the year 2015. Okay, listen carefully. When the act was drafted in the year 2013, common seal was mandatory, where the documents to be submitted, every single document submitted by company back in the day was in physical format. Where what was the proof that company submitted this document? What was the proof that company entered into transaction? Because company is an artificial person, we cannot come and ask the company to sign on the document. It was no proof for the company to be entering into contract. We have used a logic called as common seal. The first wrong impression you guys have is common seal is not a stamp. It is engraving into the paper. It leaves an mark on the paper. I'll show you the common seal tomorrow. Common seal is nothing but an engravement into the paper, not a stamp at all. Stamp is different, common seals are different. If at all the piece of paper has been engraved with the common seal, has been put in with the common seal and signed by the authorized person, then we'll assume that contract was entered by the company. But slowly as the economy developed, the digital India came into existence, this physical piece of papers were no more existing. We all started filing documents through the electronic media. Today, practically speaking, every single document to be filed with ROC has to be filed in electronic manner. There's no logic of you visiting the ROC anymore. You'll have to do everything on the MCA website itself. So this physical document common seal was no more required. Hence the Companies Amendment Act 2015 removed the mandation of common seal and indirectly brought in something called as DSC. What is DSC? Digital Signature Certificate. Now, can I use the word DSC has replaced common seal? Can I use the sentence? Digital Signature Certificate has replaced common seal. No, it has not completely replaced it. Only for the electronic documents, the DSC has replaced common seal topic, but for the physical documents, can we still use a common seal? If I'm submitting a physical document, if I'm entering into a physical contract, can I still use a common seal? Can I put the digital signature on physical paper? It is possible only when the documents are in a electronic format. So the electronic form of documents, we have replaced common seal with DSA. But for the physical documents, can we still use common seal? But Companies Act stated that common seal is mandatory or optional from here on. Then they given another option for you stating that if you don't have common seal, make sure that it is signed by certain set of people in the company. It should be signed by one director and one company secretary. If there is no existence of common seal, if you have common seal, put in the common seal, put in authorized person signature, that should be fine. But if you don't have common seal after 2015, because it is mandatory or optional, I'll have to sign it by whom? Now, get the bifurcation clear. This signing is required when it is physical document or electronic document. If it is electronic document, I'll use the concept of DSC. If it is physical document, because I don't have common seal, I'll get it signed by one director, one company secretary. Sir, why two persons? If it is left out to a single person, there's a high chance of fraud. If at all it is been left out to a single person to authorize everything, there's a high chance that he might misuse the company's powers. Hence, we have put in two people so that one or the other person will be genuine enough to come out with the wrongful activities if done by the person. So one director and one company secretary, but appointing company secretary is not required for every single company. Company secretaries are a lot costlier as compared to other professions because of the legal compliances. Just imagine this, you are a business owner. You have three different options. You have three different options for the legal compliances. Whom do you believe? No second thought in it? Now, for the legal compliances relating to Companies Act, whom do you believe? But what chapter are we studying now? Companies Act. Whether I can say you also as a cost accountant have knowledge of Companies Act. Company secretary also has knowledge, but your mind always believes that company secretary is a little more expert in the area. Will believe him rather than compare to a cost accountant. Even though cost accountant has knowledge of company law, you'll still believe the company secretary. And if you have made any non-compliance in legal formalities, it'll have a reputation loss in the market. It'll have a huge impact on the company if you have not complied with regulations. Hence, no company wants to take risk. Company always chooses a company secretary. Hence, company secretary obviously taking advantage of the situation charges a premium amount. The same work, ROC filings done by a CA, done by a company secretary will be at least twice or thrice the amount of fee. If a CA is charging say 10,000, 20,000, CA is going to charge at least 40, 50,000. He'll be a lot premium than compared to a CA when it comes to the compliance procedure. Hence, Companies Act doesn't mandate every single company to have company secretary. We'll discuss the applicability later. But if at all you're not a company not required to appoint company secretary, our intention was we have to make sure that it should be signed by multiple people to make sure that there is no fraud. Now, if there is no company secretary, it will be signed by two directors. We'll replace the company secretary with another director. It will be signed by. But sir, all this is required only when the company has no common seal. After 2015, before 2015, common seal was mandatory. After 2015, common seal is. And we divided the categories into physical documents and electronic documents. For electronic documents, we have our DSC. For physical documents, we may have the common seal. If the common seal is not existing, it will be signed by one director, one company secretary. If the CS is not existing, two directors. That's your entire logic of common seal. Any doubts in the five features? Transferability is something which I have to still explain. I'll come with this logic with the private and public company definitions. Any doubt until this? Give me the definitions. What's the company's definition given under section number 2, subsection 20? Company means a company which is incorporated under this act or any other previous company law. And what else we have discussed? Section numbers 179. Powers of a director. Powers of a board. Powers are always given to a single director or all the directors. So we'll be using the word powers of a board. That's it we have discussed as of now. Based on this, give me the logic of what's the time? Okay, give me quick answers on this. Corporate wheel. Who is hiding behind the corporate will? And the board of directors, they're using the company as a puppet. They're giving directions to the company to in order to go enter into contract with the third party is only able to see the third party can come and file a suit only on the acts done by the company who is liable. But actually speaking, who is doing all this? Actually speaking, the shareholders of board of directors are the persons giving directions. Company doesn't have brain. Company is not the actual person doing all these activities. They're not actual person responsible for it. If imagine this, company being a artificial person not having brain, if the shareholders state that go kidnap Deepak, they'll go kidnap Deepak. Got the logic? If the company, if the shareholders are giving directions that company go kidnap Deepak, they'll go kidnap Deepak. They don't know what is right, they don't know what is wrong, they don't know what is legal, they don't know what is illegal. It is an artificial person, doesn't have a brain at all. So, actually speaking, can the shareholders misuse this power? Misuse the power of separate legal entity and enter into all sorts of illegal transactions and simply raise their hands and say that we didn't do it. Who did that? Company. Acts done by company who is liable? Go arrest the company. Then the company side states that the court has been in special circumstances given a chance to remove the corporate veil, lift the corporate veil. Once the corporate veil is lifted out, now give me the answer. We can see whom, not only the company but also the persons who are behind the company who are actually responsible for the transaction. So there are certain situations where we'll also make that persons responsible for the transaction liable. That is called as what? Lifting of corporate veil. So what concept will I apply usually? Corporate veil or lifting of corporate veil? What concept will I apply usually on a daily basis? Corporate veil. If I believe that the corporate veil has been misused, then the court will lift. Can you and I lift the corporate veil? No. Who has a power? Only the court. Court has a power to lift the corporate veil. If it is lifted, who is be liable? The company or the persons behind the company who are actually responsible for the transaction will be held liable. Any doubt in this introduction? You have this in inter-level, so I'm going a little quick on this. Lifting of corporate veil is nothing but removing the corporate veil concept, disregarding the logic of corporate veil, and making the persons who are behind the company actually responsible for the transaction liable. Any doubt in that? And who can remove the corporate veil? Who can lift the corporate veil? Only the court. But usually, what concept will I apply every single time? Corporate veil. But if that is not providing the intentions, then I'll go for lifting of corporate veil. In our syllabus also, they have not given the entire case studies. They have given few points. You will go through one small case study. Case study name is also not required. Don't have to remember. Daimler Co Limited versus Continental Tire and Rubber Co Limited. You guys don't have to remember the case study's name. Just listen to the concept quickly. And I'm not going to explain. Okay, fine. I'll go through one basic concept. Wait. This is it is India. Okay. This is Pakistan. Okay. Okay. For example, Prashant has entered into contract with a citizen of Pakistan for importing goods into India. What's happening here? Who is importing goods? Where is he located? In India. And where is the seller located? In Pakistan, and for which he has to pay an amount of price. Whether India and Pakistan are enemies or friends? Technically speaking, friends. Okay. As of now, India doesn't have any wrong relations with any country in the world. Technically speaking, we still don't consider them as enemies, assuming a war has been declared. Hope not, but assuming war has been declared, India and Pakistan will be now classified as enemies. Now what's happening here? Prashant is entering into contract. He's trading goods with a person who is in Pakistan. Once the amount is paid, say assuming he pays an amount of 10 crores for the goods so imported into India, Prashant pays how much amount? 10 crores. this person has to pay taxes first. Once the money is generated into his hand, the person in Pakistan has to pay taxes. He'll pay taxes to the Pakistan government. Say, assuming 30% of money is paid as tax, 3 crores directly goes into the hands of Pakistan government. The rest of 7 crores in his hand, he'll go enter into transactions, and whenever he go purchase a property or enter into a transaction, he'll also pay certain amount of tax. So, indirectly speaking, can I say, remove this, Prashant is paying 3 crores to the Pakistan government, anti-national. What is he doing? He's paying money to whom? Pakistan government. How much? 3 crores indirectly. And what will Pakistan government do in the eve of war? They'll use this money for war activities. That will be again imposing, sending missiles or something on India. So can I say this person is trying anti-national? Whether this person is indirectly trying to harm Indian society? Whether this transaction is allowed or not allowed? Because he's trading with an alien enemy. If you're trading with an enemy, the enemy will always use that money to detriment the country back. So our society will be affected. Hence, trading with alien enemy is valid or void? Allowed or not allowed? Because end of the day, if you're trading with an enemy, that money indirectly flows to the government, and the government uses the money for war purposes, which is loss for our society. So this transaction is valid or void? Based on that logic, give me the answers here. It is in the World War II, England and Germany, obviously. Remember the World War II concepts? Idea number? Any idea about World War II? So we will not go into the history class now, but started in 1939, ended in 1945, was predominantly between Germany and England. Adolf Hitler from Germany and the UK government, England. These were the two major countries in the World War II. Obviously, India was also dragged into the World War because India was being controlled, ruled by whom? England. We were also dragged into the war. We were also participating in the war without any will, but we were dragged into the war back then. So, give me the logic here. If a company is located in England and it is entering into a contract with a person located in Germany, whether it is trading with alien enemy, allowed or not allowed? Not allowed. Straight away not allowed. But the problem was this company never entered into contract in Germany. This company entered into contract with people in England itself, with different companies and different persons in England itself. Now give me the basics. Where is the company located? Where was the company incorporated? England. Where was the company doing business activities? England. Is it any way connected with Germany? No. Then receiving this, these goods were sold on a credit basis. Can this company recover this money from the buyer who has purchased goods? Yes. But what happened is, once the money is recovered, this company which is incorporated in England has all its board of directors and all of its shareholders residing in Germany. Where are the board of directors located? Where are the shareholders located? Where is the company incorporated? England. Where is the company doing business activities? England. Where did the company sell goods? England. Now, if this amount has been recovered, what will the company do with this amount? Company might pay salary. Company might distribute dividend. And by doing so, the money will flow back to Germany. It is indirectly trading with alien enemy. Now remove the concept of company here. Can I say this person who is paying money to the company is indirectly giving money to the German government? Allowed or not allowed? The House of Lords. The Supreme Court in India is the highest body. Similarly, in England, we use it, we call it as House of Lords. The House of Lords gave a judgment, adjudication stating that this money so recovered in the event of war will indirectly flow into Germany. Hence, it is treated as trading with alien enemy. Hence, such recovery is possible or not possible. How did the court come into this conclusion? How did the House of Lords come into conclusion? By using corporate veil or lifting the corporate veil? Now look at it. If I use the logic of corporate veil, I'll think only till here. I'll not care who is a shareholder. I'll not care who is a board of director. I'll think only till the company. And company is situated only in England, doing business only in But if I lift the corporate veil and look behind the corporate veil, the shareholders and board of directors are located in Germany. So will I use the corporate veil or lift the corporate veil? Lift the corporate veil. This is one of the examples of lifting of corporate veil. Any doubt in that? We don't have huge amount of importance into that. You don't have huge amount of content given in our syllabus, so that should be enough for us. Corporate veil and lifting of corporate veil. Any doubts in these two categories? So we'll start with the classification of companies. Uh, time won't be sufficient enough. Types of companies or classification of companies. I'll just give a brief introduction. Tomorrow we'll start the companies. How many types of companies are there? So one wrong impression students usually have is we have 15, 16, 17 type of companies, etc. No, we have only two types of companies. It should be either private or public. Any other type of company you have in our syllabuses are sub-classification of private or public. Take it as Nidhi company or dormant company, or take your small company or a one person company, holding, subsidiary, associate, government, whatever name you use, everything is a sub-classification of either a private company or a public company. We have only two types of companies in our syllabus. One is private, one is public. Now my question is, why separating companies? Why should we even separate companies? Okay, you guys do one thing. You do your research on this part. Okay, tomorrow we'll discuss about it any which ways. You do your research on this part. Companies Act has divided companies into two parts, private and public. Now the question is, why did they divide companies? Why did they have to classify the companies? Before we close off, Companies Act 2013 has a total of 470 sections in it. How many sections are there? A total of 470 sections, and all the relevant kind of rules and regulations have been put together into a single place called as a chapter. Everything related to incorporation put into a single chapter, everything relating to board of directors put into a single chapter, everything relating to the meetings put into a single chapter. So out of the entire 470 sections, to make it easy for the citizens to understand it, we divided the sections into groups, where each group contains a relevant and similar kind of sections grouped into a single thing called as a chapter. This 470 sections have been grouped into 29 different chapters. How many chapters are there in total? 29. These 29 chapters will be indirectly giving you how many sections? 470. And to help us understand the law, we have 7 schedules given. How many schedules are there? 7. So these are the very basics of Companies Act 2013. As compared to your Companies Act 1956, it had 658 or odd sections. So number of sections got reduced, number of chapters got reduced, number of schedules got reduced. It is a lot easier for us to implement Companies Act today. But Companies Act today has how many sections in total? 470. How many chapters? How many schedules? Now, the Bare Act is hardly 285 pages or something. Only 280 pages, 285 or 288 pages. Bare Act. But adding all the rules, regulations, notification, amendments that I've done, the Companies Act today comes up to somewhere around 1900 to 2000 pages. This huge book, if possible, I'll bring in the Bare Act. This will be Bare Act with the rules, regulation. It will be this huge. The entire Companies Act. Now think about it. Is it possible for a company to follow all the rules and regulations? That's where your answer lies. Go do your own researches, types of companies, why the companies are classified into different categories. Do your research, come back tomorrow, we'll discuss it any which ways. Any doubts in today's class? Clear? We'll continue tomorrow. Thank you, ma.